Hi viewers, I am Dr. Jetling Ellosa and you well aware that I am running a channel called Law Speeches and in the YouTube platform, and regularly I am posting my lectures on various facets and gamut of legal issues and also the world affairs. So today we discuss the recent decision of Supreme Court with regard to categorization of scheduled caste and scheduled tribes. So before embarking into the details of the issue, I would like to request all of you to subscribe to my channel by pressing the link button and watch my lectures. If you feel that these lectures are knowledgeable and perfect enough, share among your communities. So just now I am telling you that on the 1st of August of 2024, only a few couple of days back, the Supreme Court had and pronounced a landmark judgment where an account it agreed, it validated the action of the governments to categorize or to say subcategorize the scheduled castes and scheduled tribes. You know, ours is a unequal society and inequality was not originated recently. It was there when the Varna system was created in our country about 5,000 years back. I am not going in details of the Varna system. The system has divided the people into different, and there was a discrimination. So centuries together, the lower caste, depressed and oppressed people, they had suffered in the hands of the few and selective upper class caste people. To avoid this, when we made the Constitution of India, the makers of the Constitution of India has introduced the positive discrimination. We have the right to equality is there under Article 14, 15, 16, 17 and 18. But the equal should be treated in equal manner, unequal should not be treated in equal manner. To bring them into the mainstream of the society, the positive discrimination concept was introduced into the Constitution of India and which has till today proved to be a successful. And we have two more articles are there, Article 341 and Article 342, which empowers the President of India to identify the scheduled castes under Article 341 and scheduled tribes under the Article 342 of the Constitution of India. So President has the power, and as on today, we have 1108 castes have been placed under the scheduled caste, and there are around 744 people, tribes have been added as a scheduled tribes by President of India under the relevant provisions which I quoted. Now, you know, since sometime around 30 or 40 years onwards, we have seen that some castes in scheduled castes or scheduled tribes, they have stating they were not fully got the benefits which they have to entitle, and in spite of the constitutional guarantees, the reservation system which was there to them has been under the clutches of few and some caste, and they only got developed. So a social and a political a momentum was started about 13 years back, and some castes, scheduled castes, people have demanding categorization of the castes, and the tribal people also demanding the same. You know, Article 341, 342 provides listing of the or identifying of the castes, but it is not providing the categorization of the castes or tribes. So as I told you that the positive discrimination is there, and if you refer to Article 15 clause number 4 and Article 16 clause number 4, where the other backward classes have been classified are categorized as a backward and more backward. The system of categorization was first time was made way back in 1950s, and such categorization which was made in the state of Madras at that time was challenged in the Supreme Court in a case called State of Madras and the Champakam Dorairajam case. And in this case, the classification of the backward and more backward classes is within the constitutionality or not were discussed, and the Supreme Court had opined that the classification which was held in the lower court, High Court of Madras, which struck down the classification, and the matter went into the Supreme Court in Champakam Rajan case, and that led the Supreme Court has stated that the classification had violated the Article 29(2) of the Constitution of India, and whenever there is a clash between the fundamental rights and directive principles of state policy, the fundamental rights will prevail. So the decision had resulted into the the first constitutional amendments in 1951. So things are like that. Again, in Indra Sahani case, which was versus Union of India, which was reported in 1992, in this case, Supreme Court had occasion to constitutionality of providing reservations to the OBCs, other backward classes in the educational institutions of the central government. And the full bench, which was constituted at that time, clearly held that the backward classes can be classified, and the court also held that a new policy has to be introduced, that is be called as a creamy layer policy. Those are developed in the backward classes. The reservation should not be extended to them, and only non-creamy layer people have right to claim the reservations. That was a decision, the Indra Saha. But here, the decision only pertains to other backward classes. But here, the a classification, a categorization of the scheduled caste and scheduled tribes is to be made or not. So there was a lot of political movement and social movements have been taking around in our country, particularly in Tamil Nadu, in Andhra Pradesh. In Andhra Pradesh, the movement was led by Manda Krishna Madiga, and in Punjab, there the Punjab government had classified them, categorized them, and in a case Dalbir Singh case, the matter went to the Supreme Court, and finally the in a case called the EV Chinnaya versus State of Andhra Pradesh, Festival Andhra Pradesh in 2004, the Supreme Court, the 5 judges, they have stated that no, the SCs or STs are homogeneous people or communities, so that they cannot be classified. Was a decision of the apex court. So since then, 30 years, the struggle is going on, struggles are going on. Then ultimately on 1st of August, the Supreme Court has given a green signal for the categorization of the classification of the SCs and STs. The judges who delivered the judgment, Those include the Chief Justice of India, Honorable Y.C. Chandrachud, and Justices B.R. Gawai, Vikram Seth, Bela M. Trivedi, Pankaj Mittal, Manoj Mishra, Satish Chandra Sharma. So these are the seven judges. 6-1 opined that the SCs or STs, they can be categorized or classified as a backward and more backward. You know, the judges have given the different judgments, but 6-1 they accepted the classification of the scheduled castes. So that means that the earlier decision of the EV Chinaya versus State of Estival Andhra Pradesh was overruled in this case. And only Justice Bela Trivedi had dissented and she gave the separate judgment and she held that the Chennaya judgment still holds good. That was the opinion of the Bela M. Trivedi. And Chief Justices Chandrachud, he opined that so we have to adopt a sort of yardstick for the classification or categorization of SCs. And this classification or categorization should be on taking empirical data and it should be subject to judicial review. And he also stated that though Article 14, 15, 16 are not applicable, but he opined that under Article 15 and 16 they can be classified or categorized because they are also socially and economically backward classes. Then the other judge, the Justice Gawai, he also endorsed the decision of the Chief Justice Chandrachud, and he gone on further. He stated that the creamy layer policy which is there for the OBCs that has so been there to the SCs and STs reservation. And the another judge, Justice Mithal, he opined that there is no existence of a caste system, only a Varna system is there, and so they can be categorized. And Justice Nath Sharma, they also concurred the decisions of the Chief Justice of India, Justice Chandrachud. So the earlier cases which was extended to the Chinnaya case has been overwhelmingly rejected or overridden by the Supreme Court by giving this or rendering this decision. Then now we discuss what are the problems for the classification. So then number one is data collection and evidences. So it the judgment is providing the classification, but the government is not having the accurate data who are or how they have to categorize. So that is a major issue the government before embarking the classification or categorization should focus upon. Then it has to balance in interests. So it is not an easy task. It is very difficult task that should be balanced without causing any sort of unrest among the SCs or STs. So that is the utmost task which the government is facing by this decision. Then there is a political resistance. So in our country, the political parties have not taken a similar view. Some political parties are supporting the classification and some may not be supporting the classification because of their political exigencies. So that is another important issue to be tackled, and the social tensions. Suppose the government takes a decision for classification, it may lead to some kind of tensions, unrest in other concerned parties that has to be tackled, and there is a administrative burden. It is not a easy that it requires lot of manpower to identify all such classification issues. And moreover, in our country, because of the COVID, we have not undertaken the census of India in 2021, and the next census were planned for the 2031. And basically, the government is taking the yardstick as a 2011 census because it was fully comprehensive manner it was held. And another issue the Supreme Court has given here in this case is that the states have the power to classify. No central government involvement is required because in every state different kinds of situations are there. So it is the states to look after this matter. So this is a very important issue concerning the very depressed and oppressed classes of societies because they were depressed or oppressed for centuries together. Now only they're joining into the mainstream. So by taking and the all these measures, the government should go further and to see that there should not be any sort of controversies. Tension should be arisen in implementing the decision. So thank you one and all for watching my lecture.